I finally just sold my house for nothing because I had no choice, because they were going to evict me and I couldn't afford to have an eviction on my name.
This is where it begins, and already you can feel the tension building beneath the surface. A routine courtroom opening, but nothing about this case is routine. On one side, you have Anthony Randolph, a man with a known history, standing in front of a judge who clearly remembers him. On the other, a victim who is about to step forward not just with a statement, but with a story that completely complicates the narrative. This isn't a clean-cut case of victim versus defendant. This is messy, emotional, deeply intertwined lives. And right now, the court is about to hear from someone who isn't asking for protection, but for change. That alone flips expectations. Why would someone in her position want contact modified instead of enforced? What's really going on behind the scenes here? Because as this unfolds, it becomes clear. This case isn't just about law. It's about dependency, survival, and decisions that don't fit neatly into legal boxes.
Let's call the case, people, versus Anthony Randolph.
Sylvana Reed, Assistant Public Defender with and on behalf of Mr. Randolph. Please state your name for the record, sir.
Anthony Randolph.
All right.
Teresa Claire on behalf of probation. Your Honor, the victim Angelica Gonzalez is present. She would like to address the court to request there being no contact.
All right. Why don't he have a seat? And where is she?
Ready?
State your name, please.
Angelica Gonzalez.
Okay. Tell me what you want me to know.
Well, I was here last week and I didn't ask for the no contact order to be removed. I asked for it to be changed to a non-consensual. At that hearing, you said you would sign an order, and then I didn't hear anything until I found out that it was rejected.
Rejected by whom?
Prosecutor.
Okay.
I reached out to my victim's advocate, who I have not spoken to since June 27th. I still have not heard from her. The only reason why I know this court date was because I have talked to Ms. Polera, and she told me to be here today to ask again. I am struggling. We have lost our home. I had to move an entire 3-bedroom house by myself. I have 2 torn ACLs, a frozen shoulder, anxiety and panic disorder that I've had to deal with all of this by myself. And I don't think it's fair that I have to take the burden of all the responsibilities. I cannot get into an apartment because I quit my job 3 days after this incident, where I worked for a police department for 7 years. So I have no job. I have no home.
Now the weight of this situation starts to hit hard. This isn't just a legal issue anymore. It's a collapse of an entire life structure. She's not speaking like someone detached from the defendant. She's speaking like someone whose survival is tied to him. Losing a job tied to law enforcement, losing financial stability, and now standing in court asking for a modification instead of distance. It raises serious questions. From a legal standpoint, this puts the court in a difficult position. The system is designed to protect victims, but what happens when the victim is asking for a path that might reintroduce risk? And emotionally, you can hear the desperation. This isn't calculated, it's reactive. It's someone trying to regain control in a situation where everything has spiraled. The court now has to balance 2 competing realities: her immediate needs versus long-term safety risks.
I'm living in my car. I finally just sold my house for nothing because I had no choice, because they were going to evict me and I couldn't afford to have an eviction on my name. I have since been taking care, the entire time Anthony's been locked up, I have been taking care of his son. He has extreme behavior issues, and the only people who can take care of him is me and Anthony. I am still taking care of him. I enrolled him back in Saline schools. I have been taking him to school every day and taking care of him. He's not my child, and he wants his dad. Dad is the only person who can help him. I'm trying to make sure he doesn't end up like his mother or his father. Anthony's problem is alcohol. It always has been alcohol. He is two different people. And I asked that if he's on alcohol tether, he doesn't drink. And he's a completely different person. I have tried to get into an apartment, even with my funds. They won't let me get into an apartment because I have no income for the last 60 days. And I just don't know what to do anymore. I can't get help from anybody because I'm not a drug addict. I don't have my own kids. The only option I have is to go into a shelter, and I don't think that's fair to me. I'm the only person who does everything that they're supposed to, and I'm being punished. Clearly, if I have an issue with Anthony, I have no problem calling the police. And I just want this to be over with.
This is a critical turning point in her testimony. She's trying to establish credibility, trying to reassure the court that she understands boundaries, that she's capable of calling for help if things go wrong. But here's the problem. From a legal perspective, that assurance doesn't eliminate risk. It confirms it exists. The court isn't just evaluating her intentions, it's evaluating patterns. And patterns matter more than promises. What she's really saying is that she's willing to manage the risk herself. But the court's job is to prevent that risk from escalating in the first place. There's also emotional fatigue here. She wants closure, resolution, something to stabilize her life. But urgency from a victim doesn't override caution from the bench. This is where frustration starts clashing with legal responsibility.
And I know I called Miss Kirby, and I know I had a fit, and I know I called Miss Valera, and I had a fit too, but I'm so frustrated. I don't know what to do anymore. My entire life is falling apart. And I know I played a part in that incident too. We literally argued for hours that day. For hours. And to the point where I just couldn't do it no more. Sorry, my chest is beating really bad.
Sure.
So all I'm asking is, I just need the no contact order to change to something where we can have contact so I can have help applying for somewhere to live. That's all. I just need help. I just need help.
I'll let you go on in a moment, but first of all, the very first thing that you stated, so that you understand, it wasn't that I was necessarily opposed to it.
Judge Simpson steps in here, and immediately, the tone shifts from emotional to procedural. He's clarifying something important. The denial wasn't personal, it was structural. Courts rely on agreement from both sides, especially in cases involving safety concerns. This is a key legal principle. Consensus matters when modifying protective orders, but listen closely, he's also subtly redirecting responsibility toward the prosecutor's office. That's not deflection, that's jurisdictional reality. The prosecution evaluates risk differently than the victim might, and this creates tension, because from her perspective, she's being blocked. From the system's perspective, she's being protected. This disconnect is where many courtroom conflicts emerge. And now, the judge is preparing to explain why her request isn't as simple as she believes.
I needed to have both sides sort of give me as I'm recalling it, is if everybody could agree to do it, then we could do it. Prosecutor's office is looking out for your safety. They may have a different assessment of where you are than you do.
Well, I was told the reason why they said no was because of his facial expression. And I'm sure he was probably upset because, once again, his attorney failed to appear, just like he failed to speak to him for 4 weeks while he was locked up. I would be frustrated and angry too.
Well,
especially when you're losing your home and your child.
Let me say this, and that is, and I think Mr. Randolph knows this, that I don't want to say we have a history, but we had to deal with it before, okay?
I've known you for a long time if you don't know that either.
Pardon?
I've known you for a long time, but you probably don't know that. Your daughter went to Girl Scouts with my sister way back in the day.
Given the age of my daughter, you probably it had to be way back.
Long time ago.
And I have to admit, maybe as a bad father, I wasn't really participating with the girls. But I get you. Okay. So, and I just want to put it this way. Part of my concern also was that Mr. Randolph can do what he needs to do.
Now the judge introduces something that changes everything. History. Not just case history, but personal familiarity. That matters. When a judge has prior exposure to a defendant, it shapes how risk is evaluated. He's not speculating. He's recalling behavior patterns. And then comes the critical factor, alcohol. This becomes the central issue in the case. Not the argument, not the incident. Alcohol. From a legal standpoint, this is huge, because substance abuse introduces unpredictability. And unpredictability is exactly what courts try to eliminate in protective decisions. The judge isn't dismissing her request. He's framing it within a larger behavioral cycle. And that cycle is what's driving hesitation.
Does what he needs to do. And you said it perfectly. When he's not drinking, you get a whole different, I mean, I can't even describe it as necessarily Jekyll and Hyde. It's worse than that.
It's hard because he's a cook. It's
Pardon?
night and day. It really is.
It is. And even, you know, part of the reason he had an impact on me, I mean, I remember defendants, I remember things, but he had an impact on me because when, I can't remember exactly when it was, but he came in, was just the most angry, obnoxious human being in the world before me. When he was in for a little while and he stopped drinking, he actually...
He's extremely smart. He's funny.
Yeah. I mean, and
extremely
then
intelligent.
He came back after having an episode where he was drinking.
Yeah.
And that beast is the only way I can describe it. Came back out.
Yeah.
Got him sober. That other person came back.
And I've been with Anthony for almost 4 years now. When I met him, he was living in sober living. He was actually a friend of a friend. And there's been a dramatic change. Like, we've been able to maintain a home this entire time. He's been able to maintain his job. I kept contact with his job every single 2 weeks because we finally found a job that he wants to go to. You know, that this could be a career. Like, he really has made extreme strides. He got his children back. One lives with us full time.
Here she pivots to rehabilitation. She's building a case, not legally, but emotionally, for Anthony's improvement, stability, employment, family responsibility. These are all factors courts do consider. But there's a problem. Progress doesn't erase relapse risk, and she even admits the trigger: stress, mental health struggles, and ultimately alcohol. This actually reinforces the court's concern rather than reducing it, because it shows a pattern of improvement followed by regression. And in legal decision-making, consistency matters more than potential. She's trying to show who he can be. The court is focused on who he has been under pressure. That gap is where this case sits.
It's just, and that unfortunately was part of the issue, was his child came back to live with us. He had ran out of his meds, decided not to refill them because he thought he was better. Unfortunately, this is the cycle with mental health. His trigger started going with his son being back because he feels like he's failing him, and started drinking again. So I get it. I 100% get it.
No, I know you do. And so, and I say that because of this. When Anthony, so the thing about Anthony is Anthony wants to take care of those around him, wants to take care of his family. When things don't quite go the right way, he turns to a bottle. That what that ultimately leads to is it leads to him letting down everybody that's around him. And just so that you know, I get your frustration. I do on everything. And I need you to understand, though, that, and I'm going to go back to talking about the prosecutor's position. They're also aware in dealing with this. Part of their obligation, just so that you, because you got to put it in all of its context. Part of their obligation is making sure that you're safe.
Right.
Now,
And I get that.
well, I don't know if you do, because that's also my obligation.
Right.
And so, to the extent that there might be a possibility that he hasn't completely dried out, that he may drink and do whatever, given his history, for both, and I'm not here to speak for the prosecutor, but I'll speak for myself, that's a huge red flag to me.
And that's why I
That
request he
I
stays on the
can't-
alcohol
hold on a
tether.
moment.
Sorry, I'm sorry.
I can't lift the no contact because that's the big red flag. Because the moment he starts doing that, horrible things happen that no one can control. And certainly you can call the police.
This is the first clear denial, and it's grounded in risk assessment. The judge identifies a red flag, and that language is important. In legal terms, a red flag doesn't mean certainty. It means unacceptable risk. The moment alcohol re-enters the picture, the court loses control over outcomes. And that's exactly what he's explaining. Even if she calls the police later, the damage in between can't be undone. This is preventive law in action. The court isn't reacting, it's anticipating. And that's why her request fails at this stage. The system prioritizes safety over situational hardship.
You can, and I know that you will do that. I don't have any issue with that. But what damage he potentially can cause between that time and that time, nobody knows.
But isn't that the point of him being on probation and on an alcohol tether? So that everyone does
Well,
know?
it is. But understand something. This is the way I am. I'm not going to do anything until I'm sure that he can conduct himself properly, that he can do the things that are necessary to take care of you, to take care of his child. Because when he doesn't, the situation that you're in now happens or something worse. And I think he understands that about me. Because we kind of had our run in, and I think he thought for a moment he could win. Hey, but that he quickly was bemused of that. So I'm not saying that I won't do this, and I get it. Okay, so let me address a couple of things that we're gonna. You've got, how old's the child?
He's 11.
Okay. So before you leave here, I want to give you a number to call. It's HAWK. It's Housing
They
Access.
won't give me assistance because he's not my child.
Notice the shift here. The judge moves from denial to assistance. This is strategic. When the court can't grant a request, it often redirects towards support mechanisms. Housing resources, referrals, these are attempts to stabilize her situation without increasing risk. This is also where the court acknowledges her struggle without compromising its position. It's not ignoring her hardship, it's addressing it differently. And legally, that matters. Because it shows the court is balancing empathy with responsibility.
Okay.
I've tried.
When,
I can't go to
when-
safe house because he's not my
Oh,
child.
hold on. You got to let me talk.
I'm sorry.
Okay. When was that conversation that you had with them?
I'm sorry.
When did you have the conversation with HAWK?
The week I found out that I had to move, that I had 30 days to move out of my house.
Okay.
So this was
So,
like June 20 something. Because they gave me 30 days. I had to be out on the 14th. So July,
Okay,
oh, sorry, July like 14th, 15th, somewhere around there.
okay. All right. So you're in the Saline area, is that?
That's where we lived. I was able to get a hotel. We're staying out in Monroe County currently.
Okay.
So I'm driving him back and forth to Saline schools.
Okay, so before you leave here, let me give some information to whomever regarding the housing issue, because I handle the housing docket here, so I can.
Yeah, I was going to end up going in front of you for the eviction if I didn't move out.
All right. Yeah, it all comes back to me, right?
I know.
All right. Okay, was there anything else you wanted to tell me, ma'am? All right, look, I get right now that it's really hard, okay? And I get also that what you want to do is you want to lash out because it's hard.
This moment is psychological, not legal. The judge is addressing emotional behavior, specifically the urge to lash out under stress. And this is important because courtroom behavior often reflects underlying pressure. He's not correcting facts, he's reframing perspective. He's telling her that progress can't be rushed, that resolution takes time. From a retention standpoint, this is where viewers start to see the human side of the bench. But from a structural standpoint, nothing changes. The order still stands, the risk still exists, the system remains firm.
I'm so frustrated.
I know. But here's what you have to do. Sometimes you have to kind of just sort of, and I know you know this, you have to kind of just walk that journey step by step. You can't kind of rush it. You want to get to a certain spot, but you can't do that. Okay? But one thing that you got to believe, and I believe this about everybody that's sitting in this courtroom, nobody wants harm to come to you. And the thing is, I know you know that, but you sometimes I think all of us, we know that, but we need to yell at somebody, right? Because in the end, nothing's changed, but we feel better for a moment.
Right.
Okay. And, and again, I'm not here to advocate for anybody that's participating in the courtroom. But the one thing that I know about the people that are in my courtroom, they're good people. They care about you.
I just don't feel like that.
Hold on.
I don't feel that way.
I know. And you're not going to feel that way. Because if I don't rule in.
Well, no,
listen,
I get
hold
that.
Hold on a minute. If I don't do what you want me to do, you're going to think I don't care. People care in different ways. Okay? And when they're telling you we can't agree to something, they're not doing that just out of spite because they hate you. They're not doing that even because they hate Mr. Randolph.
This is where Judge Simpson reinforces a critical misunderstanding that often fuels frustration in cases like this. The refusal she's facing is not emotional, not reactive, and definitely not personal. It's procedural. Every decision here is filtered through a risk lens, not a sympathy lens. When the judge says they're not acting on a spike, he's addressing the assumption that the system is being stubborn or dismissive. In reality, it's doing exactly what it's designed to do: slow things down when there's uncertainty. And here's the deeper issue. From her perspective, urgency is survival. From the court's perspective, urgency is danger. Those two viewpoints are fundamentally incompatible. This is why these cases feel so frustrating to the people involved. Because even when someone is telling the truth, even when their struggle is real, the system doesn't move based on emotional intensity. It moves based on predictability and control. And right now, the court doesn't have that control.
We've all got an obligation to make sure that the situation's safe. Okay? But we're not there. None of us are there at that moment. And so we can only go with what we know. Okay. And here's the bottom line. Bottom line to Mr. Randolph, because he's the key to this in a lot of ways. He's got to stop drinking and he's got to dry out.
Yeah.
And he has to get himself on a track where he can do that. Because the good thing for him is that I know once he does that, he can do the right thing.
Right.
Everybody wants that to happen because ultimately, if that happens, you're safe, child's safe, he's safe, and everything moves along. So I'm not going to tell you can't yell at somebody. If you want to yell at me, you can yell at me. I get people yell at me all the time. Especially my daughter that you talked about. And when she does, I just have to look like I care.
Right.
All right. So, but the thing here is just understand that nobody is trying to make your life difficult. Nobody is trying to just say, I just want her to have all of these problems. None of us. None of us are trying to do that at all.
Right.
But you also have to understand that sort of where we see the world. We know about this case.
This is a rare moment where the judge openly explains perspective bias, and it's crucial. The court doesn't just see this one moment. It sees history, patterns, and outcomes from similar cases. That broader exposure changes everything. When he says where we see the world, he's talking about institutional memory, cases where victims asked for flexibility and it ended in harm. That experience becomes part of every future decision. And legally, that's justified. Courts are allowed, even expected, to consider patterns beyond a single incident. This is where her individual situation gets absorbed into a larger risk category. It may feel unfair to her, but from a legal standpoint, it's consistent. The system isn't evaluating her case in isolation, it's evaluating it in context of what has happened before. That's why hesitation exists. That's why caution overrides immediate need.
But if you come in or talk to the prosecutor and they just do what you want. We've had cases where we've done that. And regrettably, I'm not saying that it's necessarily based upon gender, but where women have ended up in a horrible situation.
This is what I went to school for. I worked for a police department.
I know, and you know that.
I know.
And so that's what my point that I'm making to you. Yes, they're going to hesitate. Yes, they're going to try to make sure everything's in place. That's part of their job. All right. So understand that. Okay. And, and I'll say this in terms of victims advocates, because I've dealt with a number of them. Ms. Roddy.
That's not who my victims advocate was.
Okay. But I will tell you with Ms. Roddy, if she's the one that's going to deal with you or whomever, the team of victim advocates at the prosecutor's office are great. They're going to listen to you. They're going to try to get in contact with you. They're going to understand what you're telling them. Not always going to agree.
Well, that's the thing. I haven't had communication. So,
okay, but they're not always going to agree. But when they don't agree with you, do not, and this goes even for the prosecutor and even for defense counsel, don't think because they don't agree with you that they're not hearing. Okay? And sometimes all we really want in life is just somebody to hear us. Right? That's probably in a lot of ways why you're here talking to me.
This is one of the most revealing lines in the entire hearing. The judge shifts from law to human behavior, acknowledging that sometimes people come to court not just for decisions, but to be heard. And that matters more than it seems. Because when someone feels unheard, they escalate, they push harder, they demand outcomes. But when they feel acknowledged, even without getting what they want, tension can reduce. From a courtroom dynamics perspective, this is strategic de-escalation. The judge isn't changing the ruling, He's changing the emotional temperature, and it works, because now the focus moves away from conflict and toward acceptance. But here's the key. Being heard does not equal getting approval. And that distinction is what defines this entire exchange.
So let me ask you, as we've gone through this for whatever time period.
Sorry.
No, it's okay. It's okay. Do you think I heard you?
Yeah.
Then we can't do any better than that. Okay. Anything else you want to tell me? All right. Don't leave here without the information. And I'll probably give it to Ms. Blair to try to get through to you as to, not going to say maneuvering things, but let's see what we can do. Okay.
Here for now.
Well, you can have a seat, but
Well, I mean, yeah.
before you're done, I want to make sure to try to get that. Okay. All right. Thank you.
Can I put this in?
Yeah. Go ahead. Thank you for asking, because a lot of people just walk in my well and then she's got to take them down, and then it's a whole big
I know.
thing. All right. Mr. Randall. Okay.
Today is the date and time for sentencing. We have reviewed probation's recommendation. We do not have any additions, deletions, or corrections other than that we would also like to have that no contact order lifted. I will note that Mr. Randolph has been on the scram tether for about 2.5 months now. The most recent report that I received from Community Corrections as of Friday states that he has not had any violations. And part of probation's recommendation is that he remains on that scram tether. So I believe that that is one of the most helpful provisions there in that recommendation. And I think that that will help him maintain his sobriety. He's also, as part of that recommendation, supposed to do substance abuse treatment. And so he has already reached out to the Home of New Vision and is on a waiting list for them to reach back out to him.
Now the defense shifts the narrative toward rehabilitation and compliance. This is a classic sentencing strategy, highlighting proactive steps to show reduced risk. Sobriety monitoring, treatment enrollment, employment stability. These are all strong indicators in favor of leniency, but timing matters. These actions are recent, and in legal evaluation, short-term compliance doesn't outweigh long-term patterns. The court is going to weigh consistency over intention. Still, this does create movement. It shows that Anthony is responding to consequences, that he's taking steps to stabilize his life. The question now becomes, is this a temporary correction or a sustainable change? Because that answer determines how much trust the court is willing to extend.
To get that process started. So I believe that he is currently sober and doing well and taking the steps that he needs to ensure that. And that is all I believe that we have to say on that matter today. But I think he is in a better place than he was previously, and will continue to follow those provisions as requested by probation.
I have
Mr. Randolph, anything you want to say?
Your Honor, I absolutely, this was, I don't know how many wake-up calls I'm going to need in life, but this was a wake-up call for me to get back on track with my sobriety and reconnect with some people. There've been, you probably have been aware, there've been a numerous amount of losses in the community over the last several months, one of which was a sponsor that also kind of hit me hard, brought up some triggering issues. The long story short, with that and the stress going on in my life, it caused me to have a relapse, for which I'm paying the consequences. I'm paying the price for that right now. So I am back on track. I am back at work. I'm doing what I need to do. I'm back connected with the community. And I realize the importance of my sobriety, Your Honor. I realize that it's critical.
You remember the first time we met?
I was probably about 18 years old. You tried to put one of those things on my leg that I got on now, and I wasn't having it. I did 30 days in jail.
Yeah, you did. You really thought at that moment that what I was ordering was a negotiation, right? That somehow or another you had something to say about it, right?
This is a direct confrontation with past behavior, and it's deliberate. The judge is reminding Anthony of a pattern: resistance to authority, refusal to comply, and the illusion of control. In legal terms, this speaks to accountability. If a defendant has a history of challenging orders instead of following them, it reduces the court's confidence in future compliance. And that's exactly what's happening here. The judge isn't just recalling a story, he's establishing a behavioral baseline. And that baseline matters more than recent improvements. Because in sentencing, the court isn't just deciding punishment, it's predicting future behavior, and past defiance becomes a major factor in that prediction.
Yeah, I was unwilling to change my lifestyle or even work on myself at that age.
And so, Mr. Randolph, when as time went on and you started to realize that you needed to stay sober, when you were sober, things were better, weren't they?
Yes, Your Honor.
And then you'd end up back before me. And every time you come before me, what's the one thing? Alcohol. Every time.
Literally.
What?
I said literally.
Yeah, every time. That may not be the charge, but underlying, you started drinking. Then you got your significant other up here. The very fact that the two of us could sit here without your participation and talk about day and night Randolph, one when they're drinking, one when they're not, and we understood each other very clearly. That should tell you something. I mean, I'm not involved in your life except when you end up doing something stupid, right? But I know that about you, and she's up there verifying. And I think, and it happened the last time that I think that I saw you, I think that was the last time, that when you do drink, I guess in some ways if it were just you that was headed downhill and everything, that's one thing. But as evidence today, it's everybody around you.
This is where the scope of impact expands. The judge makes it clear, this isn't just about Anthony anymore. It's about everyone affected by his actions. Family, partner, child. This is collateral damage. And in legal reasoning, that broad impact increases the seriousness of the case. It's no longer an isolated issue. It's a pattern that disrupts multiple lives. This is also where accountability becomes unavoidable. Because even if intention isn't malicious, the outcome still matters. And the outcome here has been instability, stress, and risk for others. That's what the court is focusing on. Not just what he did, but what it caused.
I know I feel an extreme amount of guilt about it.
You know, it's funny, Mr. Randolph, a lot of people come before me and say that. I believe you. I know you do. Because deep down inside, without the alcohol, and I meant it when I talked to the victim in the case, said, you're a good person. You might think I hate you. I don't hate you.
Thank you, Your Honor.
I just need you to do better and lead the life I know you can lead.
Absolutely.
But that life you can't have alcohol in.
I understand.
And you know also, Mr. Randolph, particularly for your child, if nothing else, that if I catch you drinking, you know what I'm going to do.
I absolutely do.
Because I'm not shy about a lot of things. Just think back to our first battle. Yeah, whole thing. And then you thought you would win. They were going to win. Then next thing you know, you're in 30 days. Right?
Absolutely.
See, I can smile about it now. One day you'll be able to smile about it. It was kind of funny because you really thought you were going to win. This wasn't happening. All right. How are you guys going to get yourselves housed?
I currently work at Selene Electronics. I work about 50 hours a week. I've been there for well over 6 months. I can provide income requirements, whatever that they need.
Here, Anthony attempts to establish stability. It is about employment, income, and a plan for housing. These are critical factors in sentencing. Courts look for structure, responsibility, and forward movement, and on the surface, this checks those boxes. But again, the issue isn't capability, it's consistency. He's shown he can maintain stability. The problem is maintaining it under pressure. That's where previous breakdowns occurred. So while this strengthens his position, it doesn't eliminate concern. The court now has to decide how much weight to give current effort versus past relapse, and that balance is what shapes the final ruling.
They were able to hold my job for me, so I've been back to work for about 2 weeks now. I should have another paycheck coming within a week. I may be able to get some help from Hawk with a security deposit as far as getting the initial upfront costs taken care of.
All right.
I've been searching and filling out applications to apartments, getting information from apartments so that I can go ahead and continue to get on the right track. I was trying to hopefully see what type of resolution would happen with this court matter so I could consult with Angelica before signing a lease on anything. So that's kind of been one of the holdups there.
I was also going to state I could refer him to our AIM division and see if there are any resources or assistance they.
Yeah, they're just going to confuse things. All right, here's, don't mean that badly, they just will. Here's what I need you to do. What actually he said is actually the way to go. There's one barrier, and that's the contact, because he has the child. And so that's what can sort of pave the way, although he hasn't been working long. Like he said, they might be able to help with the security deposit, and they might be able to help with, since there's a family there, with the beginning part of that rent. Okay. So here's. Okay. She's sick. Okay. All right. Sins of the court. I'm going to place you on 24 months probation. You're to pay $655 fines and costs, $720 probation oversight fees. I'm going to have that as arranged by probation as a payment plan. And Ms. Polera on this one, because he's going to have another $555 in cost. I don't want anything worried about until they get themselves housed. Yes. Okay. So I'm not going to be expecting you to pay until you get yourself in a place and get your family settled.
Okay. Thank you.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a domestic violence program as directed by probation. You're to complete a substance abuse assessment of at home of New Vision, follow all treatment recommendations with status reports to probation. What I'm going to indicate regarding Angelica Gonzalez, I will change that provision to no non-consensual contact. You understand that?
I do. Thank you, Your Honor.
I'm going to strike 8 regarding the residence. Do not assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. You're to report to probation as requested by probation, including any home visits. You're to maintain employment with verification to probation. You're to comply with all circuit court orders, if any. The scram tether will continue I'm not putting an end on that. It's just going to continue. If I got to keep you on it for 2 years to keep you sober, that's what it's going to be. You hear me?
Yes.
I'll set a review hearing in this matter November 6, 2023 at 1 p.m. I'll order 365 days in jail, credit 40. The balance is suspended. On count 3, the malicious destruction of property less than 200, 24 months probation, $555 fines and court costs payable as I previously indicated. Comply with all the terms as set forth in count 2 that I just announced under domestic violence. Second, I'll order 93 days in jail, credit 40, balance suspended.
Thank you.
Buddy, good luck to you.
I appreciate
Do the right thing.
it. Sounding like my dad now.
I'm one of those too.
I know.
So you should listen to your dad. Take care.
This is the final decision, and it reflects a controlled compromise. The court does not fully lift the no-contact order, but it modifies it to allow non-consensual contact. That's a precise legal adjustment. It maintains protection while introducing limited flexibility. Alongside that, the sentence is structured around accountability, probation, financial penalties, mandatory treatment, and strict sobriety enforcement through a scram tether. This is not leniency, it's conditional opportunity. The judge is giving Anthony a path forward, but it's tightly controlled. Any deviation, especially involving alcohol, will likely trigger immediate consequences. And that's the key takeaway. The court is not trusting change, it's enforcing structure. Judge Simpson's ruling reflects exactly that balance between caution and possibility. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.